Bonjour à tous.
Hello, everybody. Well, I'm sorry, I'm going to do my presentation in French, so normally you should be hearing an English translation coming through. I don't speak English very well, and especially in this context, it's much more careful for me to be careful with the language I use, and this is why I preferred to do my presentation in French. And this is why I would like to thank very much the organizers first for inviting me. I'd like to present my experience as a whistleblower in the LuxLeaks. It's a very particular personal history of mine, and I shall look essentially with the interaction with the European Court of Human Rights and how the case law of the European Court has influenced the judgment which was given in my case. And this is going to be the occasion to give the impression of a simple European citizen about this European right for the protection of human rights. I was, and I'm still a French citizen, I was an auditor, an accountant in Luxembourg. As many French citizens, I was extremely happy to find very, very fast a very well-paid job in Luxembourg. And of course, well, like anybody, I thought that there was a rather accommodating tax regime in Luxembourg, and I knew what I was going in for anyway. But anyway, I think that my essential use for the public as an auditor was more important, because in my activity I wanted to make sure that the accountings were done in a truthful and faithful way. In the course of my functions, I saw that there were some tax practices which were much more extreme than I could have imagined beforehand. There were some people who were very accommodating and managed to only pay their tax on an extremely minor proportion of their revenues, going to a proportion of about 3% only. So from then on, I was made aware more and more of what was going on, and then I started to talk about it publicly. I gave witness as an anonymous witness, not quoting any of my enterprises, on a French radio channel, and I also expressed some comments on an internet blog where I did say what I was seeing in the exercise of my functions. I was saying Bureau 6 of the tax offices of Luxembourg, which was validating a great number of tax decisions through which multinational entities, through fiscal advisors such as mine, PricewaterhouseCoopers, was allowing most of the biggest multinationals of the planet to evade quite a lot of tax with the approval of the Luxembourg authorities. This is what I've written in a blog on internet. And at the same time, I decided to hand in my notice, thinking about changing my job. And I have successfully done so. I was asked to mention that, so I've gone into competition examinations for the public service in France. So I'm extremely happy to be still employed in another fora now. And my last day at work, just before I handed in my notice, I copied a file that entailed a lot of those tax decisions that enable a lot of multinationals to evade tax. And that goes back to 2010. And in 2014, the International Consortium for Investigative Journalism has taken all of the files that I've copied, and from Raphaël Allais, who is another whistleblower, and for many months in many countries in the whole world, they looked at those practices with a rather important media range, and there was a lot of echo from it, and through pressure from the general public's opinion, and there was an answer given by the political spheres. Of course, I'm not here to talk about tax regimes here, but I'll give some examples to give you how useful. There was a parliamentary commission in the European Parliament that looked into this, the tax committee, to look into those practices. There was an answer, a response from the European Union with a new directive for automatic fiscal exchanges of those tax forms. Normally what happened before, very confidentially between multinationals and the tax offices, but it was well known by everybody in Europe and elsewhere, those documents were being fed into the documents of competition committee with a certain number of convictions actually decided upon in Luxembourg and elsewhere. So that was very good for the European democracy, of course. This is not just my own role. Essentially, it's the role of the media that enabled to make the opinion aware of this public problem. And this is a very important case to say. The fate handed over to the whistleblower has a direct impact on the freedom of expression, because without sources, journalists has a very limited power. Another repercussion of this case was indeed the legal court cases. My employer realized that there was a great leak coming directly from their offices, and they went into an internal inquiry and identified me and complained to the Luxembourg authorities, and the PP decided to condemn me for different causes. It's very particular to Luxembourg. I'm not going to go into the detail, but it's a sort of keeping illegally some information. And the first court case was at the spring of 2016, and I was condemned to 1 month of prison and 1,600 euros of fine. The principal defense of my lawyers was, of course, the case law of the European Court, and notably Article 10 of the Convention. And the first judgment was given in June 2016, freely accessible. So before really giving you my own personal interpretation of it, you can go and look at it on the web. And they're considering that there is a debate now on enhancing the freedom of expression protection of journalists. That there's no protecting framework as such set up in Europe. And the argumentations have been sorted out, saying that all the information was insufficient. Well, the public interest was recognized very highly and highlighted. We realized, as Raphaël Allais, we were a whistleblower. My conviction was maintained. I appealed, and the Court of Appeal of Luxembourg gave its judgment last week, in fact, as recent than that. And as opposition to the first court case, they did a more careful examination of the court case of the European Court. And I was acquitted for the breach of professional secrecy, thanks to the examination of the famous 5 criteria of the European Convention, and I fulfill all of those 5 criteria. But only at the time when I hand over the document to the journalist. So it was back in 2011, but I'm not complying when I take out the documents in 2010 when I actually steal them. So, according to my lawyers, this decision taken by a national judge implementing the European Court's judgment is rather not one-off. Unseen in European history, and that's a partial success, but I'm still condemned to 6 months of prison. Well, of course, I can detail this by saying how much this is a victory. Well, some of the argumentation presented by the prosecutor were contested by the lawyers. He had, in fact, said that there might have been some other alternatives to transmit all of those documents. I might have been able to transform the documents, making them anonymous and giving only extracts, and they don't give any truth to those arguments. So the criteria I totally complied with. The criteria of subsidiarity was complied with. It's an original way of looking at the European law, but this criteria was very complied with, and I did very well to give exactly the document as I received them without transforming them to the journalists. And why I'm still under a conviction of a prison sentence is that I was considering myself as a whistleblower potentially before I copied the documents. Thanks to the article of my blog, which I mentioned, I am a whistleblower in the sense of the European Convention when I transmit in 2011 to the journalists. But when I discover and take out the documents, I'm considered to be a thief. Well, I have the possibility to appeal this by going to a court of cassation, possibly in Luxembourg, and possibly also going to another appeal later on to the European Court. That's why I chose to speak in French. This is a very particular context in front of judges who might have to treat my case, and it's very delicate to talk to them in front of them now. And I haven't taken this decision to appeal to the court, just simply because I think that what is the most important thing to say, apart from my personal message to the society and to other potential whistleblowers, I think a very long and costly court case in itself is dissuasive to some potential whistleblowers, particularly that you might in the end still have your suspended sentence maintained. So I haven't taken any decision whether I'm going to appeal, yes or no. But my perception as a normal citizen is that at the time of the fact, I worked with my guts, with what I was feeling, what was my duty as a French citizen, European citizen, and I don't have a lot of legal knowledge, I must say. I didn't know at the time the European Court, I didn't know the Convention, nor its rights. And I find it very reassuring for a European citizen to have this institution that enables to reduce very much my sentence. And it might be just a step, but it's a very good step forward in the right direction. And it makes a national court to take into account a European convention. Before I conclude, I'd like to talk about the debates that we've had in the appeals judgment. The recommendation 2014-7, Principle 6, which is going into the breach of the professional secrecy. This principle, taking the example of the different lawyers, does testify that whistleblowers should not be protected when they are in breach of professional secrecy. And if this principle could be applied in the future, it would mean conviction of future whistleblowers. And for the moment, as things are standing for the moment, it was considered as only a recommendation, and this means that it is not implemented. So there was still a debate on this recommendation. This is why I wanted to mention this recommendation to send a word of warning against this limitation. And then finally, well, I've said it before, the existence of the protection of the whistleblowers through this European Court of Human Rights is extremely reassuring, but it's an extremely long process. It costs a lot, and it might be, of course, very preferable that we have a framework, first of all, to protect in the national legal framework. And in that way, I totally support the recent initiatives of the European Union, especially the public consultation which has been triggered recently by the European Union about how we should protect in the future whistleblowers. Thank you very much for your attention.